Hello, welcome back. This is Introduction to Customary Law, Part 3. I now would like to discuss with you customary law and common law, their objectives. I briefly touched this in Part 2, but I now would like to expand a little bit further. There are different objectives, customary law and a common law. Common law of England. The objective is completely different, and the Melanesian customary law, the objective is completely different. So that's why they are always at loggerheads. Sometimes they conflict with one another, and poor Papua New Guineans, Melanesians are caught in a sandwich. We need to fix this legal quagmire. We need to, and we must fix this, or else we will continue to be in a situation where we will be in a legal conflict. For instance, the modern law, the common law, and the principles of common law that we have adopted and are now applicable in the formal legal system, they are not compatible in most cases. They are not compatible with Melanesian customary law. Their objectives are completely different. The English common law is individual oriented. It's individual oriented. It seeks to penalize or benefit an individual. But whereas Melanesian customary law is community oriented. It is community oriented. It seeks to benefit or penalize a community. Melanesian customary law is community oriented, and English common law is individual oriented. Let me give you an example. For instance, if somebody commits crime of murder, if somebody kills another person, English common law will seek to single out that particular culprit, pluck him or her out, and then throw him into jail. That is because English common law is individual oriented. But Melanesian customary law will seek to not to punish the culprit, but will seek to punish the tribe or a clan. For instance, this law is very active. This law is very active, and this explains why we are facing a lot of violence in urban areas right now. This is Melanesian customary law at work, on full display. Say, for instance, a Angan man killing a Tari man somewhere at Gardens, but the Angans who are in Waigani, who have not known about those that little fight between an Angan man and a Tari man, they will take cover. Why? Because Melanesian customary law will seek to penalize not an individual but a tribe. So now the notion of tribe has evolved to assimilate and to include the creatures of legislation such as electorates and the provinces. These provinces were never tribes before. But now, for a reasonable Melanesian perspective, tribes have expanded to cover provinces, and yet provinces are creatures of legislation. The Constitution, the organic laws establish provinces. But who cares about that? For a reasonable Melanesian, these are big tribes. Therefore, Melanesian customary law can apply to tribes. So that's what. Like in a Melanesian society, we didn't have prison camps. But we did have laws, either to go to war to advance spiritually or physically, or to seek compensation. We are not interested in the culprit, but we can kill, or some, and the culprit who has killed a tribesman from another tribe. Then those the diseased tribesmen can take revenge on anyone belonging to the murderers, the one who has killed the culprit's tribe. And it is justified under Melanesian customary law, but it's not justified under common law, the criminal code. The criminal code will just put all the tribes aside, the family aside, single in on the culprit, plug him out, throw him into jail. But Melanesian customary law will seek to penalize the tribe. So it can, in revenge, they can destroy the tribe, they can destroy properties, and it's justified under Melanesian customary law. So you can see, customary law and common law, they have different objectives. One is seeking to penalize or benefit a community, is community oriented, whereas the other one is seeking to benefit or penalize an individual, and therefore it is individual oriented. So now we have to find a law that comes in between, utilizing these two laws together, so that just set aside those principles that are not good, but extract worthy principles and then formulate a law that will appreciate both modern law, common law, and the customary law. That law is the underlying law. The founding fathers have made provisions for the development of that law that will utilize both regimes of law. If we don't do that, common law will be active in the formal legal systems, and the customary law will be active outside of the formal legal systems, and we will continue to have conflicts of laws. We will end up have a society that is confused. Like for instance, police officers, or lawyers themselves, or law enforcement agencies, they are the ones who enforce the law. They are the ones who know the law. But when they have personal issues, they don't come to court to resolve. They go to their families, they talk it over, they use Melanesian customary law. So both laws are active, and both laws have different objectives. So underlying law is the way to go, and we should develop it. Whether we like it or not, ours is now, whether we like it or not, we must develop it. But we must pay more emphasis on the customary law. Because, once again, I must say, PNG is not England. Therefore, the English common law is not readily applicable in PNG. It's not compatible with Melanesian culture. Melanesian culture, Melanesian values are completely different from British, English, Anglo-Saxon cultures. Therefore, we must develop a law that is compatible with the prevailing circumstances of the country. That is the underlying law. So I will continue with this discussion in part 4. So please don't go away, keep watching, subscribe, and continue to look out for the next part, and that is part 4. I will talk more about underlying law, customary law, and English common law. So we are still on the introductory part, so I'm just giving some brief I'm just making some brief discussions here, but as we go further, I will plug out the different aspects of the underlying law, and then we will look at it in detail, or look at them in detail. Thank you so much. See you again.